This video is a basic 6th grade civics education as it pertains to civil court proceedings, specifically custody proceedings. There's a natural and logical connection between the law, the petitioner's petition, the court's order, and the recourse if errors or falsehoods occur. If the law is in the format of 1, 2, 3, it naturally and logically follows that the petitioner's petition will be in the format of 1, 2, 3. When the format of the petition follows the format of the law, it allows everyone in the courtroom to clearly see whether or not the petitioner has met his burden of proof. The respondent can then prepare a response, which allows everyone in the courtroom to see that the respondent had the opportunity to prepare and respond to each point, correct any falsehoods or errors in the petitions, and move forward. When the court's order follows the format of both the law and the petitioner's petition, it allows everyone in the courtroom to clearly see that the judge is enforcing the law. Everything is on the up and up. Then later, if number 1 is proven to be false or contain errors, and if number 2 is proven to be false or contain errors, and if number 3 is proven to be false or contain errors, there's a natural and logical process to correct the faulty court order, even if this leaves the petitioner with consequences of misrepresenting the entire case to the court. Now to talk about what goes wrong in custody cases that involve domestic violence between the parties. Custody law, even for temporary orders, requires the petitioner to prove 10 separate points that altogether comprise what's known as the best interest of the child. What should happen here is the petitioner should make a written defendable case showing 10 points. This would demonstrate that he has carried his burden of proof. Now, in custody cases where the petitioner is an abuser, he often refuses to file any form of written petition. When the petitioner is an abuser, he often cannot show any of the 10 points required by law, and he doesn't want everyone in the courtroom to clearly see that he cannot carry his burden of proof. Refusing to make a case is advantageous to the abusive parent. It makes it possible for him to create a smokescreen of unsubstantiated slander against the respondent instead of carrying his burden of proof. Refusing to file a written petition puts the abusive custody petitioner in complete control. He can say anything, knowing that it will not be verified in any way or subject to any kind of reality check of any kind. Refusing to file a written petition renders the respondent completely unable to prepare a response of any kind. Getting to the court's order, because there was not any petition that followed the format of law, the court's order often doesn't state the reasons, which stumps the natural and logical recourse to correct the errors and falsehoods. For example, if Dad files an intake form to get a court date to establish overnight visitation based on having a new apartment in Kitty Hawk, he's going to get it. The judge writes an order, but doesn't write the address of the apartment. Then later, when it is discovered that Dad's new apartment is a P.O. box at a UPS store, and no one even knows where the child is spending the court-ordered overnight visitations, it cannot be reviewed or corrected by the court, and Dad won't be held responsible for committing a fraud against the court. Another example, if Dad files an intake form to get a court date to increase overnight visitation based on having a new stable residence in Pocosin, he's going to get it. The judge writes an order, but doesn't write the address of the new residence in Pocosin. Then later, when it is discovered that Dad's new stable residence in Pocosin is a construction site based on a short-term construction contract, with construction debris everywhere and nowhere for the child to safely play, it cannot be reviewed or corrected by the court, and Dad won't be held responsible for committing a fraud against the court. One last example. If Dad testifies in custody court that he's been working as an IT engineer at a highly regarded national research agency for a year, then Mom, who was married to Dad for 13 years, testifies that Dad's last known job was as a night shift custodian at a high school, that he had left that job because of health issues, was on long-term unemployment, followed by a job through a temp agency, which was followed by another long-term unemployment. Mom further testifies that over the prior year, Dad has claimed at least 3 employers, and that the state's Child Support Enforcement Authority has never been able to verify any of Dad's alleged employers. Now, based on Mom's testimony, everyone in the courtroom should have a general idea that Dad is not telling the truth. But Dad manipulates the court into believing his story by falsely saying that Mom has mental issues. The court gives Dad custody based on his false testimony about his employment, which was never put in writing by either the petitioner Dad or the court order. Then 58 days later, the child is on emergency welfare known as TANF, proving that Dad does not actually have a stable job at a highly regarded national research agency. Now, the custody situation will not be reviewed or corrected by the court, and Dad won't be held responsible for committing a fraud against the court. In conclusion, this hurts children, allowing abusive fathers to file for court hearings and to request changing child custody from safe mothers without filing any petition that follows the format of law, and then giving these abusive fathers custody anyway, leaves children stuck where they should not even have to be. So the change that is needed to the law is to disallow oral argument as a standalone form of child custody petition. Oral argument should supplement the prepared written petition, not replace it. Thank you for watching and listening.